In this episode of People Matter, I'm looking at the recent cases on religion or belief discrimination in the workplace, and looking at what is a belief protected by the Equality Act and cases on clashes of belief. So the question of what can be a protected belief has been looked at on a number of occasions, starting with Granger and Nicholson. Now, amongst other aspects, for a belief to be protected, Granger established that a belief must be worthy of respect in a democratic society. Now, what was meant by a belief worthy of respect was then explored by the EAT in June 2021 in the context of a case looking at whether or not gender-critical beliefs could be protected. This was the Forstater and CGD case. Now, in that case, the EAT said that the bar is not to be set too high, and it's only beliefs which are akin to that of pursuing totalitarianism or advocating Nazism or espousing violence and hatred in the gravest forms that should be capable of being not worthy of respect in a democratic society. Fast forward to May 2022. A tribunal looked again at this in 3 Miles and Royal Veterinary Hospital. In a first instance decision, the tribunal found that radical vegan beliefs were not protected, where the claimant's belief included the moral obligation to take positive action to reduce or prevent the suffering of animals, and crucially, which included trespassing on private land and disobeying unjust laws if it was done to expose animal suffering. For the tribunal, it was that last bit, the fact that the claimant's belief included an element of law-breaking, which was key to their decision. And they said, it's not open to individuals to decide which laws are worthy of respect and which can be disobeyed. So, whereas Forstater made it clear that employers should not get too lost on the issue of what is or is not a belief worthy of respect, a point can be taken where a belief entails in unlawful action. Now, alongside this, there have been 3 important judgments dealing with whether a claimant had been discriminated against because of their gender-critical beliefs. In June 2022, the EAT gave judgment in Makareth and DWP. Now, this was a case of alleged indirect discrimination arising from an employer's policy that their service users, benefits claimants, should be referred to by their preferred pronouns. Although the EAT decided that the claimant's gender-critical beliefs were protected by the Equality Act, they found that the DWP had not discriminated against the claimant when it dismissed him because he would not comply with this policy. This was because the dismissal was objectively justified. That is, it was a proportionate means of achieving a legitimate aim. In this case, the DWP had a clear policy supported by evidence. It took time to listen to the claimant, gave him time to reflect, and genuinely explored alternative solutions to try to avoid the clash of rights. Just 7 days later, on 6th of July 2022, the Forstater case returned to the courts, this time looking at whether the decision of her employer not to offer Forstater an employment contract or renew her visiting fellowship had been made because of her beliefs, not, as the CGD had argued, because of the way she expressed her beliefs in a number of tweets. The ET found that Forstater had been directly discriminated against, and key to the decision was the ET's finding that the tweets in question were not objectively offensive or unreasonable. So the CGD's less favourable treatment must have been because of her beliefs, rather than the way she expressed them. Most recently, the tribunal has found in Bailey and Garden Court Chambers on 25th July 2022 that a barrister who held gender-critical beliefs had been directly discriminated against when her chambers tweeted that it would carry out an investigation into complaints about the claimant's tweets, and then, when its investigation concluded that the claimant's tweets were likely to have breached the Bar Standard Board's core duties. So, whilst it's difficult to draw too many conclusions, there are 3 takeaways. Firstly, 2 of the cases where the claimant succeeded involved employers responding to comments made outside of work on social media. Now, this shows the difficulty for employers dealing with complaints from employees upset about views expressed by colleagues outside of work on hot topic and controversial beliefs, such as gender-critical beliefs. Now, particularly in the age of social media, where posts can be picked up and shared very quickly, and employers may be concerned to protect their own reputation, what is clear is there is a line, which is hard to draw, on the extent to which an employer can take action against its employees because they hold beliefs that are controversial and potentially divisive within work. Secondly, whilst the line is hard to draw, there appears to be a distinction between actions taken by employers because of the way the belief was expressed, rather than the belief itself. Now, whilst in Forstater, the ET went through the claimant's tweets one by one, and they concluded that none of them were objectively offensive or unreasonable in the way they were expressed, although that decision was not unanimous in relation to one of the tweets. And this led the ET to conclude that the employer's decision not to renew her visiting fellowship or to offer her employment was because of her belief itself, rather than the way she had expressed them. On the other hand, in 3 Miles, that's the militant vegan case, the ET found that even if the claimant's beliefs had been protected, the claimant's expression of them, by committing illegal acts and breaching her employer's social media policy, were an objectionable and inappropriate manifestation of her beliefs. Now, therefore, her employer's decision to dismiss her was because of the expression of her beliefs, rather than just because of the beliefs themselves. Thirdly, employers are on safer grounds, where a clash of beliefs arises in respect of the way an employer delivers its service, echoing previous cases involving same-sex counselling. The courts were prepared to accept an employer could objectively justify policies which put those of a belief at a disadvantage. Now, it helped in Makareth and DWP that there was a clear risk that the claimant would come into contact with transgender service users in his role, and that the DWP gave the claimant time to reflect on his position. It was genuinely willing to explore alternative solutions. So in the end, it was able to justify its policy that its staff should refer to service users by their preferred pronouns. As with previous clash of rights cases, it's proving easier to defend claims of indirect discrimination as opposed to direct discrimination. Thank you for listening, and keep an eye out for future updates.